Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin, LLP. This is another opportunity for those of you just tuning in to go ahead and ask any and all questions you have with respect to your work, your workplace rights as an employee, or for that matter, as an employer as well. If you're an employer or an owner of a small business or medium-sized business and you're tuning in and wondering about what to do with an employee, or wondering as an employee what your rights might be if you're having a difficult time with your employer, maybe you've been let go from your job, maybe your employer is asking you to change your employment in some form or fashion. Well, really, if it has anything to do with your employment, this is the place to be. This is the time for you to go ahead and ask your question of an employment lawyer. Please don't ask me a criminal law related question or a family law question, but certainly when it has to do with your workplace rights, you are in the right place. And again, this is a live Q&A for the next half hour. We're going to be answering all of our questions on whatever platform you're watching this on. Please go ahead and post your question right now, and I promise I will get to it before the end of the half hour. Before I get into a couple of topics I wanted to touch on today to maybe get the ball rolling, I did want to provide our contact information. First off is our website address. If you're looking for a starting point, if you're dealing with a situation at work and you maybe want to have a quick sense of what your rights are or what the situation might entail from a legal point of view, go to employmentlawyer.ca. You see it on the screen right now. We've got a ton of resources on that website, articles, blog posts, news clippings, and that should give you an initial sense of the kind of situation you're dealing with. If it's a termination, well, of course, we've got a severance pay calculator on our website and online that you can use to calculate how much severance you're going to be owed. If you're dealing with what you might think is a constructive dismissal, or if you've been laid off from your employment, or you're on a medical leave, another great website to use. It's on the screen right now as well, pocketemploymentlawyer.ca. It'll ask you a couple of questions and give you a sense of what your situation is. And again, that could be a severance calculation. It could be dealing with changes to your employment or human rights concerns. Perhaps go to pocketemploymentlawyer.ca. It's completely confidential. There is no cost or commitment whatsoever. You don't have to input your email address or anything like that. Of course, if you want to reach out to us, by all means, go ahead, and you could do so either through our website or through pocketemploymentlawyer.ca. I'll also give you our email address. If you want to send us a quick email and describe your situation in brief, again, all of this is confidential. All of this is free of charge. You can email us at help@employmentlawyer.ca, help@employmentlawyer.ca. Go ahead and give us a brief description of your situation. If you've been terminated, again, just let us know. Give us a sense of what's happening, and I promise someone will get back to you if you email us there. Of course, our website address has all of our contact information as well if you want to get a hold of us either over the phone or reach out to an individual lawyer in your area. Keep in mind, I'm coming to you today from Ottawa, Ontario, a bitterly cold, shall I say, Ottawa, Ontario, but we do have offices in Vancouver, in Calgary, and of course in Ontario as well, in a couple of different locations. So wherever you are, certainly if you're in those provinces, please do reach out to us if you're dealing with a workplace situation. By the way, workplace situations also include situations involving medical leaves of absence and disability insurance. Oftentimes when you are ill or medically unable to work, you will be put on a medical leave of absence by your doctor, and you should be able to apply, if you've got this benefits coverage, for short-term or long-term disability benefits. If you're dealing with a situation with the insurance company, maybe they've denied your disability benefits claim, or maybe they've told you that they'll be cutting you off in the future, or if you just have concerns about taking a medical leave of absence or what rights you might have as an employee coming back from a medical leave of absence, please go ahead and ask your question here as well. That disability insurance subject is also part of an employment situation and we can certainly handle those kinds of situations. Well, certainly if your disability benefits have been cut off and you're unable to work, that is an extremely serious situation. You need expert legal advice if you're dealing with an insurance company. Unfortunately, it does happen, and more often than you'd think, that insurance companies will deny an employee a legitimate claim to disability insurance. So do not let insurance companies or employers, for that matter, give you a hard time and deny you the compensation that you're owed. All right, I see a couple of questions lined up already, which is great. Please, for those of you just tuning in right now, if you missed the intro here, this is, of course, a live Q&A. Anything to do with employment law, with your workplace rights. If you're dealing with a difficult situation at work, maybe your boss is mistreating you, maybe they're asking you to change your position or change your compensation package in some way. Maybe you've been let go from your job and you've been offered some sort of severance, or maybe you've been let go from your job and you've been found, you've been accused of misconduct or poor performance and you haven't been offered any kind of severance. Listen, any one of those situations, you need employment advice. You need advice from an employment lawyer. This is the time. This is the place. Please go ahead and post your question. Do not mention your employer's name. You don't have to provide any personal details. Give us a brief and vague enough kind of description of the issue that you're dealing with, of the problem that you have. And I will get you on the way to resolving that workplace issue. A lot of times, employment situations are actually pretty easy to resolve. The law isn't overly complicated when it comes to employment law. And so oftentimes we could point employees in the right direction and resolve their situations pretty easily. And certainly if we're talking about termination and severance, you would be surprised and shocked how much severance employees are owed, even short-term employees, even younger employees. Severance is a significant entitlement when you're let go from your job. It's going to be more than 1 or 2 weeks, or even 1 or 2 weeks per year of service. Severance is often months and months and months. And certainly if you're a longer-term employee or an older, more senior employee, your severance entitlements could be as much as 2 years of pay. I mean, that's nothing to scoff at. If you've been let go from your job and you're looking at a severance offer, don't sign it on the spot. Even if it's a 6-figure number, even if it's significant, you think it's reasonable, make sure you speak with an employment lawyer. If it's fair, if it's reasonable, we will tell you so. But unfortunately, oftentimes, employers will lowball employees and leave them to fight for their actual fair severance entitlements. All right, let's get to a couple of articles here as we line up the questions. Again, feel free to post your questions right now, and I will answer them in a few moments. First matter I wanted to talk about, this is an interesting one that arose during the COVID-19 pandemic and is still an issue in the workplace. And we're still getting quite a number of calls and questions about these situations. And it has to do with the employer's ability to call employees back into the office to work on site, to work in the office or whatever the location might be, as opposed to working remotely from home. Again, in 2024, this is an issue that we are still dealing with. There was an article in the Financial Times that just came out not too long ago, a few days ago, that effectively says that productivity is really no better in the workplace as compared to employees that work remotely. And most employees see this request to come back to the office as kind of a power grab of employers that don't trust their employees, or just want to have eyes on them in the office, in the room per se. And again, we get tons of questions every single day about whether your employer is allowed to recall you back to the office. The answer, for better or worse, is relatively straightforward, and the answer is as follows. If it is the case, and it was always the case, that this work from home situation that probably arose because of COVID, if it was always the case and your employer made it very clear that work from home was always a temporary measure, and it was to address the concerns that arose as a result of the pandemic, and again, it was temporary in nature, and the employer reserved the right to call employees back into the office, you can find that language perhaps in a work from home policy. or in a remote work policy, or perhaps it was communicated to employees over an email or in some form or fashion, right? If the employer made clear that it was always going to be temporary, well, then in that situation, an employer would have the right to recall employees back to the office. And that's quite an obvious and straightforward situation. Again, if this was always a temporary measure, the employer does have that discretion to say, okay, well, the work from home situation is up. We'd like employees to start returning to the office. By the way, there should be some degree of notice of returning back to work. It shouldn't have to be on a moment's a notice that, effective tomorrow, you're having to come back into the office. We always advise employers, give employees as much notice as possible, right? Maybe that's a month, it might even be 2 months, but you want to give some significant amount of notice to say, to all our employees, heads up, next month, we're going to ask you to start coming back into the office. And perhaps it's a kind of split situation where you're working from home a couple of days a week and working in the office a couple of days a week. Certainly lots of employers operate in that way now. Now, that said, if you've been working from home remotely, maybe because of COVID, but maybe this was an implied or established term of employment that, for example, existed prior to COVID, or maybe even you're a short-term employer, you were hired during the pandemic or after the pandemic, and work from home was an established term of your employment. In other words, in no form or fashion was this communicated to you as temporary. Right? If it is a set term of employment that, yes, I'm working from home, it says it right there in my contract, there are no stipulations, there are no conditions, well, and your employer's trying to call you back into the office, well, then you have the right in that scenario as an employee to say, no, thank you. My contract says work from home, or you and I agreed that this would be a work from home situation, and it wasn't temporary. It wasn't conditional on X, Y, or Z. This was just a set term of employment that I was enjoyed and that I agreed to, and that you, the employer, agreed to. In a case like that, your employer actually doesn't have the right to recall you back to the office. You can stand your ground as an employee and say, no, my terms of employment are that I'm a work from home employee. You cannot call me back into the office. You can certainly stand your ground in that way. That said, it does need to be said as well that if your employer ultimately really wants you to be in the office, but you refuse, and you rightfully refuse based on those given circumstances, do keep in mind that an employer can let you go. Certainly in the private sector, in a non-unionized workplace, your employer can let you go in a situation like that. It would be a without cause termination, meaning the termination would be with severance, right? And again, your severance would likely be significant based on your age, position, and years of service, right? And you risk potentially ending the employment relationship if you're having that kind of dispute with your employer. But I would not simply back down from a remote work situation where that has become basically a permanent term of employment. So it really does depend on whether the remote work situation is a permanent established term of employment or whether it was always understood as temporary. In a temporary situation, the employer does have the right to recall you back to the office, and you should go. Otherwise, you risk being accused and potentially you risk being insubordinate, and that might lead to reprimands or recourse from your employer. So hopefully that helps. Again, it's a question that we are getting quite often still, despite the fact that we seem to be beyond any COVID-19 issues in the workplace. Remote work, whether you're working from the office or from home, remains an issue and an area of contention between employers and employees. Hopefully, most of you out there will be able to sort that situation out. Of course, if you're not sure what to do, if it's a delicate situation, then you should be reaching out to us. Don't be shy to give us a call. Numbers on the screen right now. Don't be shy to email us, visit a website. However you want to get a hold of us, feel free to. All right. Hopefully that was helpful to some of you viewing this either live right now or at a future time to the recording. Remote work is always a delicate one. Let's get to the questions, folks. Again, for those of you just tuning in right now, this is a live Q&A. So if you're dealing with a situation at work and want to know the answer to your question, if you want to ask a quick question of an employment lawyer, here we are. My name is Alex Lucifero. I'm an employment lawyer and disability insurance lawyer as well with Samfiru Tumarkin, partner with the firm. Doing this quite a long time myself, so you are certainly in the right place if you're looking for some guidance and for some information with respect to your employment concerns. So first in line is Scout, or perhaps Scott, on YouTube, who asks, I work as a subcontractor for an engineering consulting firm. They haven't paid me for the last 6 months, geez, and I'm not sure what to do. My contract is net 30 on payments. What are my options? Geez, well, I'm sorry to hear of that, Scout. Clearly, this is what we call a classic. In the employment context, it would be what we would call a constructive dismissal. You can also think of it more generally as a breach of contract situation. Listen, by your employer or this company, we could talk about, you mentioning that you're a subcontractor, Scott. Clearly, by not paying you for 6 months, they have breached the terms of your contract. Even if you don't if you don't have a written contract, whether it's a subcontractor agreement or an employment contract, Scott, listen, the basic implied terms of work, of employment, is that in exchange for your services, whatever those services are, you are paid money. You are financially remunerated for that work. If your employer stops paying you, that is the classic definition of a breach of contract. You can now consider your employment or your contract, Scott, at an end, and obtain your severance entitlements. Now, maybe, Scott, you're wondering, well, hold on here. I'm a subcontractor. Why are you talking severance? Well, here's the reality of the situation, Scott. And obviously, we'd need to chat in more detail. So I'd recommend you give us a call at the office. Let's set up a time to chat. More than happy to walk you through this myself, by the way. Almost always, and I mean, I literally mean, 9+ out of 10 times, when we speak to someone who calls themselves a subcontractor, I just dealt with a situation like this actually earlier this week, or when they consider themselves a contractor or in business for themselves. Listen, if this is your full-time gig, and you work for this company exclusively, and they pay you at regular intervals, every 30 days or so, as you said, right? And you are integral to the operation of the company. Maybe you even hold yourself out as a representative of the company. I mean, all of these things, and I imagine, Scott, I probably tick a few of those boxes in your situation, at least. In that situation, you are either going to be considered, despite whatever contract you might have signed, you're going to be considered an employee of the company, not a subcontractor, not a contractor. There's a decent chance, if not a good chance, that you are an employee of the company, and you are going to be owed severance as a result. Even, by the way, if you are not an out-and-out employee of an employer, if you are a contractor and you consider yourself a contractor, but again, you work for one company and one company only, and all the money you earned is through that one company, you may still be what we call a dependent contractor, a dependent contractor. And as a dependent contractor, you would still be owed severance based on how long you've been working for this company, your age, and your position at the time of your termination. And as I said, the longer your service, the more senior your position, the older you are, your severance entitlements could be as much as 24 months of pay or 2 years of pay. That could be obviously a heck of a lot of money. And so, Scott, certainly in a situation where the company hasn't paid you for 6 months, you're owed those outstanding wages. Obviously, if you haven't been paid for work that you've performed, that's a no-brainer. You can also consider your contract at an end, get your severance entitlements, and get moving on to new employment. Clearly, if you're dealing with a company that's not paying you, this is not a situation you want to be in moving forward. So give us a call at the office, Scott. Send us an email at help@employmentlawyer.ca. I promise we will be able to help you through this situation. Odds are, again, not only are you owed those unpaid wages, you're probably looking at some sort of severance, and let's figure out what that is exactly and what the best way to pursue a situation like that is. Great question to get us started here. Next in line as we scroll through is Mimi on YouTube. Mimi asks, I recently signed an employment agreement for a new position. I asked for a signed copy for my records, but the employer says it's not their process. I only have the contract with my own signature on it. Should I be worried about this? Me, I don't think you should be worried about whether the employer signed it or not, or kind of having a finalized a copy. I'd be more worried, quite frankly, about the specific terms in that employment agreement. So it is kind of the substance of the agreement that matters more than the form. It is odd, I do have to say, that the employer doesn't want to provide a copy. That doesn't sound right. You have the right, by the way, to that documentation. You would have the right to anything that's in your HR file, and certainly your employment agreement or your employment contract would be one of them. I do have a bigger concern, though, to be honest, Mimi. Listen, when you're receiving a job offer and you're starting a new job, I think it's, it is human nature to look at the big ticket items. What's the position they're offering me? What's the pay? What are the benefits? How much vacation do I have? Those are, of course, the most important things that are going to matter you day to day and week to week and month to month. However, Mimi, I would be, and actually for all our listeners right now, if you're being offered a new job, or even if you're in your current employment, and your employer is asking you to sign an updated or a new employment contract, that should be a red flag because, especially nowadays, and more the case as the years go by, most employment contracts will have terms in them that will potentially limit, for example, how much severance you might be owed if you're ever let go. So maybe rather than worrying about what signature lines are on the contract, have a look at that agreement. If there are any paragraphs or subparagraphs in there that are, that speak to termination or severance, you should probably review those and make sure you know what they mean and know what you might be owed in the event of a termination, so that at least you're prepared and you have that knowledge right ahead of time. There could also be terms in an employment contract that do a couple of things that employers aren't necessarily allowed to do without that contract in place. For example, there might be language in an employment contract that allows the employer to change your terms of employment, change your position, perhaps, who you report to, what kind of job responsibilities you have. Uh, an employer is not allowed actually to make those kinds of changes kind of by default. They can only make those kinds of changes, again, if it's written into your employment contract. That's language to look out for as well. Another example, and the last one I'll give here because it's such an important one, is temporary layoff language. It's really important to note, and this is important for all the tradespeople out there, and it's also relevant. We see it a lot in IT, for example. For one reason or another, these employees are temporarily laid off from time to time, and it's really important to know that a temporary layoff actually isn't, again, by default, legal. Your employer is not allowed to temporarily lay you off, at least without your consent, unless it is a term that is written into your employment contract, or unless you agree to it, or you've agreed to it previously. So, I mean, if you're okay with the layoff, that's not going to be an issue. But it's important to note you can actually dispute a temporary layoff if it's not in your contract, right? And oftentimes it's the better choice to dispute a temporary layoff. You don't want to be on layoff, sitting at home, collecting zero pay and just waiting for the employer to call you back to work. Oftentimes that's a terrible situation to be in. But if there's temporary layoff language in your employment contract, you might be stuck in that situation. So it's another term of employment that you should keep an eye on. Mimi, I'm less worried about the signature lines and less worried, although again, it's quite odd that your employer doesn't want to send you a copy. I'd be more worried about the actual substance of the contract and those kinds of terms that I've just mentioned. If you're looking to have a contract reviewed, if and I actually just had a conversation with a very nice gentleman this morning about this. If you've signed an employment contract already and you're worried about the terms in that contract in the event of a termination or in the event of a change to your employment, go ahead and give us a call, send us an email, reach out to us however you want. Let's have a chat about it. We want to be able to, to fill you in on what the legalities of your situation are, what rights you might have in one of those situations. And it's important to know that kind of stuff to plan for the future. All right, next up in line is Annie on Facebook. And by the way, Mimi and Scott, thanks very much for your questions. Those were great. Next up is Annie. Annie asks, I recently resigned from my position, but my employer has listed my status as terminated. Is this something I should be worried about? I'd like to know why you resigned, Annie, and I'd be curious to know why your employer kind of listed your status as terminated. Listen, accuracy and factual information is always the best policy. So if your status, whatever that means, perhaps on a record of employment, doesn't match up with the reality of the situation, yeah, listen, I would be worried about that to the extent that you want things to make sense and you want things to line up. And so if your record of employment doesn't match the reality of the situation, I would reach out to my employer and say, hey, what's going on with this? Well, there seems to be an error here. Perhaps it was just a clerical error, right? And you could get it sorted that way, Annie. But the status is terminated does trigger my curiosity here, in the sense that I'd like to know the reason for your resignation, Annie, because if you resigned from an employment, and not just you, Annie, but any employee, if you're resigning from your employment in protest of something, so we've been talking over the course of the segment today about changes to your employment, or difficulties that you might be having with your employer. If you resign from your job, again, in protest, maybe because your employer has asked you to accept a different position, or they've asked you to accept some sort of pay cut, or maybe you're dealing with a kind of a harassment or a bullying situation at work and you can't take it anymore. You've tried to resolve the situation, that hasn't worked, nobody is listening to you, and so you've just decided to resign. That is what we call a constructive dismissal situation. Resigning in protest to either a change to the terms of your employment or to a toxic work environment or harassment in the workplace is actually going to be considered a termination and not a resignation, in which case, by the way, you would be owed severance as an employee. So again, it goes back to this concept of what we call constructive dismissal. A constructive dismissal is whenever the employer isn't holding up its end of the bargain and holding up your established terms of employment, right? You would be able to consider that a breach of contract, leave that employment, and obtain severance anyway. Now, that said, I don't want employees out there that are dealing with a difficult situation at work to just resign their employment and then ask for severance. It's not that straightforward. But if you're dealing with a difficult situation at work, things are changing, your employers ask you to do something that you don't want to do, or you're dealing with, again, a toxic, negative work environment, maybe you're being bullied or harassed, right? Before you do anything, give us a call. Let's have a chat, right? It may be that your best option is to resign in protest and claim constructive dismissal. And oftentimes that is the best option because you want to get out of that terrible work environment, right? But don't do it without legal advice. Oftentimes situations are a little bit more delicate than that. Oftentimes you need to build a case, so to speak, before you resign. But Annie, that's what intrigues me about your situation. I'd be curious to know why you resigned, why your employer marked your status as terminated. And if you can't resolve, if it's just a clerical error, so be it. You can figure that out for yourself with your employer. I'd reach out to them and correct that mistake. If there's more to the story, if there's a reason why you resigned, right? And again, you were effectively resigning under protest. I think that's the best way to describe it. Then I would certainly want to have a chat with you. Let's figure out exactly why you resigned and what the situation was. And it is certainly possible that you'd be dealing with a constructive dismissal situation, in which case you'd be owed severance. I will squeeze in one last question because I want to make sure I get to all of them, and we've got about a minute or so left. Corey on YouTube asks, I went off work due to a toxic workplace. Do I have any legal recourse against them? I should add that my workplace is unionized, but representation is lacking. I'm currently on LTD. Corey, great question. Listen, you may very well have recourse against your employer if you can prove that this was a toxic work environment, keeping in mind that when we talk about a toxic work environment, what we're really talking about here is harassment in the workplace. And so that is something that needs to be provable, right? If you're simply, for example, not really getting along with your manager, or maybe there are some minor things that are causing you some stress here and there, I don't know if that would necessarily classify from a legal point of view as harassment in the workplace. But if it does rise to the level of harassment or bullying, certainly if you have a manager or a boss that's mistreating you and talking down to you, and we certainly see situations where managers will swear and yell at employees and berate employees in front of others. I mean, if we're talking about that kind of situation, let me tell you, that's the classic example of harassment in the workplace. You would have recourse in that situation, Corey. However, because you are a unionized employee, your recourse can only be through your union. You are not able, as a unionized employee, to hire outside legal representation to deal with this. It has to be through a grievance. It has to be through your legal, through your union rep. That is, I understand that unions can sometimes differ in how much they protect their employees or not, or what battles they choose to fight or not. All I can say, Corey, is make sure you follow up with your union rep. Make sure you have an in-depth conversation with them. That is the only way that you can really go. And ultimately, if your union is not being helpful, I hate to say it, but you might be stuck. It's one of the advantages of non-unionized workplaces. I get it. As a unionized employee, you have job protection. Oftentimes, the benefits are better, the wages might be better. But as a non-unionized employee, you do have more options, and I hate to say it, more rights if you're dealing with a constructive dismissal situation or harassment in the workplace. And certainly your entitlements would be better as a non-unionized employee when it comes to severance. So listen, pros and cons to unionized and non-unionized work, but there is a difference there. We will leave it at that, folks. We went a little overtime for today, which is great. I appreciate all of the questions. For those of you who are maybe a little too shy to ask a question today, or perhaps you were just tuning in at the end of the segment, we will be doing another segment, I believe tomorrow, if I'm not mistaken. And so you can tune in there. We, of course, do these almost every single day of the week, if not every day of the week. So please tune in next time. Thank you all so much for watching. Have yourselves a great rest of the week, and take care.